All right, y'all, I hope you are buckled up. You are ready for one of the weirdest unconstitutional rulings, but you still can't have your candy that you're ever going to hear. We're going to take it a little adventure around the Sixth Circuit. Guys, this one is bizarre. But as you get in here, we're going to try and make heads of tails of what's going on. Make sure you hit that like button, subscribe to the channel, turn the notification bell on, make sure we've got audio, video. We are good over here. And with that, let's dive right in. All right, as you get in here, throw those emojis, comments, do all the things that are necessary to make this machine drive. There you guys are. Excellent, awesome, good stuff. Audio, video, incredible. You guys are always delivering. All right, listen. We have got to talk about one of the weirdest rulings you're ever going to see. Now, you can jump right over there at Braden LOA on X. You can make sure you are part of the conversation as we continue to grind for freedom and pass our Second Amendment along to the next generation and destroy the gun controllers who would take it from them. It's a great time. Make sure you're a part of it. And, of course, as you guys are filtering in, if you have not yet, check out the Second Press. This is our membership. This is our movement. This is our website. Make sure you get over there. We've got merch. We've got the movement itself you can join to be a part of. We've got exclusive content over there. You can be part of the mailing list. Guys, there is something for everybody. There's a link in the description box below. Check it out, secondpress.co. You can literally fuel the fight for a cup of coffee a month, and the amount of things that we're getting done are incredible. All right. We have the right amount of people, and just as a side note, guys, genuinely, the notifications and the distribution of our videos right now are like in the tank. So any sharing that you do, liking, dropping emojis, anything is amazing. All right. Let's get into this situation right here because this is one of the weirdest things I've read in a while. Now, this is from AMOLAN, a little hat tip to them. This is their reporting. The Sixth Circuit just handed down a wild machine gun ruling. They admitted machine guns are protected arms under the Second Amendment. Then they turn around and they said the ban still stands because they're dangerous and unusual. Now, for those of you who have been in the fight for a while, you'll recognize that language. That's an ode to the Heller part of the conversation of the Heller decision. If you're newer, you'll recognize the first half of that as the Bruen decision. What they're effectively doing is they're saying, yeah, of course, they're protected. We're going to throw a little common use in there. I'm going to show you the whole article in a second. A little common use in there. Then we're going to throw a little bit of unusual and dangerous. And then at the end of the day, we're going to rule it unconstitutional, but then say you still can't have them. What? Okay. Let's just dive in. That was my high level. Again, hat tip to AMOLAN. And as you guys get in here, make sure you hit that like button and you send this out because it is hard on these YouTube streets. Okay. As I advertised, Sixth Circuit admits machine guns are protected by the Second Amendment, and this is an article written by John Crump. Okay. As we get into this, put your stupid hat on because you're going to need it to translate. The United States Court of Appeals for the Sixth Circuit ruled that machine guns are protected by the Second Amendment, but said a ban on the category of firearms passes constitutional muster. Okay. How can something be unconstitutional? And then then banning that thing that is enforced by the unconstitutionality be constitutional. Like, this is some judge, the ways that only judges can do. All right, let's keep on going. So law enforcement, this is the story. The officers were able to apprehend the individual, whose name is Bridges. Police then recovered a .40 caliber Glock pistol equipped with what is colloquially known as a Glock switch, or just as a switch from the man. So that's the little thing you do to a pistol and it makes it an NFA item. I'm obviously not going to show you that. I can't show you that. We're on YouTube. But it's important to understand the distinctions and all the definitions in the background here because what we're about to go into is silly. So, let's catch you up on the NFA. According to the NFA Act of 1934, the machine gun must be registered with the ATF through a long and complicated registration process, and a tax stamp of $200 must be paid. In 1986, the Firearms Owners Protection Act, or FOPA, was passed by Congress and signed into law by President Ronald Reagan, which included what is known as the Hughes Amendment. This is all these things are going to play into this in a second. This amendment to the bill closed the ATS machine gun registry for privately held machine guns. The only machine guns allowed to be transferred now are those that were manufactured before April of 1986. That's the backstory, okay? We're just inching our way towards this. The NFA violations in this case were charged at the federal level and in a Tennessee federal district criminal court. Bridges' public defender argued that the Hughes Amendment violated the Second Amendment of the Constitution. Now we're getting somewhere. All right, the Hughes Amendment, the thing that says you can't create these machine guns in private hands after April 1986. Sorry, I'm fighting the crud from goals, but that's what we're talking about. That was what was being challenged as unconstitutional. According to the Supreme Court in Madison versus Mulberry, if a law is unconstitutional, then a person is not required to comply with it. Okay, you see why I'm covering this. All of these little breadcrumbs are leading to the ultimate conclusion of, y'all can't do this. But then they just take a hard left off the roller coaster track and they just make up their own. But all of these things, including that part, Madison versus Mulberry, if a law is unconstitutional, you don't have to abide by it. That's a bit of an uncomfy thing for the government control. Okay, let's get on going. After losing at the district court level, the public defender appealed to the Sixth Circuit Court of Appeals in Ohio. The case was assigned to a 3-judge panel made up of Republican appointees. The defense lawyer again argued that the law was unconstitutional because machine guns were protected by the Second Amendment, referencing several Supreme Court cases such as Bruen and Miller. These are all Supreme Court cases in the 2000s. Okay, these are recent. Let's keep going. The Sixth Circuit judges said that machine guns are bearable arms. And to them, that means that Bruen's first step was satisfied. So it complies to rule it unconstitutional with the Bruen decision. Bruen decision says, yeah, it's unconstitutional what you're doing. In the second step, the burden then falls to the state to provide historical analogs to show a law is consistent with the nation's history and tradition of firearm regulation in the country's founding era, which most believe is the ratification date of the Second Amendment in 1791. Okay, yeah, keep on going. Although Heller was monumental for Second Amendment rights, this is where it all goes off the rails, it came with a big caveat from Associate Justice Anton Scalia. Scalia wrote that an arm can be banned if it is dangerous and unusual. See how that little off-ramp shows up? You're failing all of your tests. You're failing the Bruen decision. You're failing the Miller. You're failing Marbury versus Madison. You're failing all of these things until that one little caveat of dangerous and unusual. So I know. I'm going to call it dangerous and unusual, and all of a sudden I'm fine. We're fine. You're fine. We're all good, right? That's where we're going here. All right? Let's just keep on trucking. The defense argued that machine guns are in common use and presented numbers showing over 740,000 machine guns are currently in circulation and registered with the ATF. If an arm is in common use by the police, it cannot be banned. The court rejected the given number. The court reasoned that a lot of the machine guns referenced by the defense were in the hands of law enforcement SWAT teams. They stated they believe the number is more likely on just under 200,000. 200,000? That's still a whole lot. In fact, if you're paying attention, there is a stun gun case in Massachusetts, I believe the name is Catano, that undermines the exact same number for common use, and it was ruled for common use. So, while this is a fun little game about machine guns, let's step out of that for a second. Look at AR-15s. Here, we're gonna go big here. Look at AR-15s. The same people who are saying that they're going to ban the AR-15 and they're going to take all of our gun rights from us and they ban this individual class of weapons, semi-automatics. There are more AR-15s in the United States than there are Ford F-150s. There are 24 million, according to some estimates, around AR-15s. Those are the numbers in civilian private ownership hands. And all of a sudden, you're gonna split hairs with me over 200,000 or 700,000. If this is the case, and this is considered almost common use, and you got a Catano case out of Massachusetts on stun guns, why are we even talking about it being possible for ARs? It's not even close. There are more than a freaking F-150, which is America's truck. Anyway, let's go back. The circuit court upheld the lower court's decision, although the court said that machine guns can be banned. This is the first time an appeals court ruled that machine guns are protected arms. So you can see the big problem here. Yes, machine guns are protected arms, but we're still going to ban them because they're dangerous and unusual. What? That doesn't even make sense. If you're going to say something's unconstitutional, it's unconstitutional. It doesn't become all of a sudden constitutional if you say it's dangerous. That doesn't make any sense. Also, it can be applied to any pistol if you really wanted to. Dangerous and unusual. But the whole common use thing, like, that's going to blow it out of the water. Again, CAR-15s. All right, here we go. However, this ruling does create an interesting circuit split. Other courts have considered firearms such as the AR-15 not protected under the Second Amendment. And that is the big payoff here. And there's the ruling, everything's linked. That's the big payoff here. Other courts have ruled the AR-15 as not protected because it's a military-style weapon, as they would call it. You have the Sixth Circuit, who's now saying that machine guns are perfectly fine and they are protected under the Second Amendment, but because they're dangerous and unusual. So that puts you in this weird little place of machine guns are bearable arms and they are protected. However, they are banned because they're dangerous and unusual. Then over here, you've got AR-15s in different courts and they're being banned and they're not part of the protected arms because they are dangerous and unusual, but they're even more common use. You see where this is becoming a problem? All of these things don't make sense. They don't work in the same jurisprudence. They don't work in the same thread of a tapestry, which is why you heard, what's-his-face, Kavanaugh say that they're waiting for some things to percolate before they take up the AR-15 cases. Percolate this, Cavi! Because now you got one district court saying that machine guns are protected arms. You got another one that's saying AR-15s aren't. And then at the end of the day, you've got them still being banned because they're dangerous and unusual, referencing the Heller decision. This is a mess. Anytime now, SCOTUS. That would be ideal. All right. I just saw something. You need a half a gallon of JD and stupid hat for this to make sense. Right. It doesn't make any sense. John says, wow, actually got a notification on time for a live stream. Listen, can go buy a lottery ticket. I'll tell you what, that's crazy. Coaster Fish confirms it was $200,000 for stun guns that were used. And when did judges become legislators? About 15 to 20 years ago, to be quite candid. All right, listen, people. That's what I've got for you guys. I hope you enjoyed every second of this. Thank you so much for the comments over there. Make sure you hit that like button, subscribe to the channel, turn the notification bell on. I will see you guys tomorrow. I love each and every one of you just the right amount that makes you feel comfortable for yourselves and only yourselves, and I will see you on the